Louis-Philippe. Nice to see you here. Thank you for joining us. So the topic you will be presenting on is very important, especially today. And we are thrilled to know more about the GDPR and its response to COVID-19, if it is well prepared for this situation. So I will present who will be a speaker. So Louis-Philippe worked in the field of privacy as a business lawyer, first of all. So he is academic lawyer in Quebec Bar Association, right? Yeah. And he worked in Canada, France, and Switzerland. So today our topic is dedicated to the current situation and to the situation where many governments are taking unprecedented measures to track, trace, and contain the spread of the coronavirus. And they do it by turning to digital technologies and advanced analytics to collect, process, and share data for effective frontline responses. So are we prepared as lawyers in the field of privacy to this situation? And what is the response taking into account obligations under GDPR? So we know about the situation in China, in other countries which are less, I would say, responsible with privacy rules. So what we have in place with GDPR. So Louis-Philippe, the floor is yours.
Thank you, Maria and Alexei, for your introduction. And yes, indeed, we will talk about how the word health crisis revealed the importance of the data in our daily life. As the question is extensively covered in the news, citizens realize our personal data are enrolled in the fight of the coronavirus. Data are collected and processed for different reasons. One of them is to monitor the number of cases of infection and provide daily statistics, as you might have seen on television and in the media in general. But data can also serve to map the spread of the virus, understand differences between affected regions or countries, estimate the probability that a person has been infected based on her symptoms, trace the contacts of a contaminated person, make sure quarantine people respect their confinement, or more generally, to plan public health policies. Apparently, citizens are not that concerned about sharing their personal data and letting different public and private actors processing them. Is it because of the emergency situation or the fear created by the coronavirus? But a majority of the population seems ready to give access to its data in many countries according to different polls. A study conducted by the Oliver Wyman Forum, for example, shows that respondents are inclined to share health information mainly with their doctor and their national public health authorities. You see the first two rows of information here in the table, but they are more reluctant, the public in general, to communicate a positive test result with government officials in general, employers, or through smartphone applications, which is a big concern for us today. As you might see here in these lower numbers, depending on different countries, there were surveys in Singapore, Germany, and other European countries. Their answers also change with the type of data involved. If they're open to share health information, they hesitate to allow access to their traveling, biometric, or location data. A positive attitude among the population towards sharing personal data shouldn't make us forget that the Charter of Fundamental Rights of the European Union guarantees the right to data protection, and that the provisions of the General Data Protection Regulation, the GDPR, strike a perfect balance between processing necessary information to fight the coronavirus and the respect of privacy. My presentation will mainly focus on giving keys to authorities, businesses, companies, employers, and researchers on how to legally process health data under the GDPR. We will first look at the nature of health data and their legal regime. Then we will review different situations where data are used during this pandemic and suggest ways to comply with data protection laws. There are many scenarios under which data are processed in this crisis, but I retain basically two. By tracing and tracking applications and by employers. So let's start by examining the legal regime of health data. In the current situation, a large number of personal data is processed daily by public bodies, health practitioners, and employers. Health data, of course, like symptoms, body temperature, or a positive test to coronavirus, but also at least two other types of data. Basic and identification data, like name or age, and location data. So it's important to understand what data are considered health data under the GDPR and distinguish them from other types of personal data. Article 4, paragraph 15, defines health data as personal data related to the health of a natural person, including the provision of healthcare services, which reveal information about his or her health status. The GDPR basically tells us that health data are data related to health, which is kind of tautological. Concretely, in the context of the actual COVID-19 crisis, what personal data should be considered as health data according to the GDPR? Information about testing positive to coronavirus, conducting tests on individuals, recording body temperature, or tracking down symptoms of the disease, like fever, coughing, or breathing problems. All these examples definitely qualify as health data. That kind of information is directly related to the health of a natural person, as the definition in the GDPR just told us. Details about places of stay and locations a person visited during a trip constitute personal data, that's for sure, but should they also be considered health data in this present crisis? Supervisory authorities of some member states do not classify them as such because they do not directly reveal any information about a person's health status. The bare fact that someone is in quarantine is more difficult to qualify. According to some member states' supervisory authorities, the information may be considered as health data depending on the additional details existing about the quarantine. Why the person is in quarantine, what is the goal of the quarantine, where does that quarantine take place, at home, hospital, and so on. So these questions will be answered, and then you will know if these the information about quarantine can be qualified as personal data. The first question we just ask ourselves, does the information belong to the category of health-related data? Isn't just an exercise for the legal minds. It has a direct and practical impact on the legal regime applicable to these data, and consequently on how the data should be processed. Indeed, data informing on a person's health condition belong to special categories of personal data, according to Article 9, paragraph 1 of the GDPR. They are the so-called sensitive data. These data are treated with particular consideration due to their nature. Processing such data poses significant risk to the fundamental rights and freedoms of an individual, according to Recital 51 of the GDPR. The nature of the data has prompted the European legislator to enact a special legal regime to deal with any health-related information. Processing of this type of data is paragraph 1 of Article 9 of the GDPR, unless there is an exception applicable under paragraph 2 of that same article. We will come back later to these exceptions, you will see. You now understand that some information falls under the general legal regime of data protection, while others follow special rules. We will concentrate mostly on these rules applicable to special categories of personal data for the rest of the presentation, even though we also have to take into account the other types of personal data previously mentioned. We will see how employers, public bodies, or health practitioners may legally handle sensitive data in a context requiring speedy action and decisions. Let's now turn to the first case we identified earlier, how to legally process data through health applications. Next Wednesday, the Stop COVID application will be debated at the Assemblée nationale in France. It aims at tracing contacts of infected people to prevent the spread of the virus. Last week, it was Estonia's turn to start to experiment a digital immunity passport. It collects testing data and allows third parties to have access to them through a QR code. It may be used to access the workplace, for example. We will see the legal implication of these applications in a moment. These applications are among many others developed in Europe and around the world as part of measures taken by governments to end the lockdown. Different techniques and technology are used. Some applications are evaluating the health of a person based on their symptoms. Some others are using the Bluetooth technology to trace contacts between devices. It may also be possible to combine these two approaches using algorithms and artificial intelligence to warn a person of the risk to which he is exposed or has been exposed in different public or private places. Applications like the ones mentioned here are providing an information society service and are therefore subject to general data protection laws. They do not fall under the e-privacy directive, but are the legal regime is under the GDPR. They rely primarily on the processing of these applications, smartphone applications. They rely primarily on the processing of identification, location, and health data, of course. I should mention that location-based applications have been ruled out in most European countries for concerns over privacy, but we will nonetheless take them into account in our expose. The question here is on what legal basis these apps can process the data. The processing of personal data in this context should be based primarily on consent for the specified purpose of fighting the coronavirus epidemic. It's the advice of the European Data Protection Board and also of most of the national supervisory authorities. Processing will be lawful if the person has given consent to the collecting of her ID and location data on the basis of Article 6, Paragraph 1, letter A of the GDPR, or in the case of health data, on the basis of Article 9, Paragraph 2, letter A. I should say one word here about the legal notion of consent. You may have noticed in these last two slides, if you are very attentive, that Article 6 talks about consent, as you may see here, while Article 9 refers to explicit consent. Article 9's consent must be explicitly provided by the person consents. It differs from the general notion of consent that you have in other articles of the GDPR. It means that the consent must be freely given, specific, informed, and unambiguous, according to the definition of Article 4, paragraph 11 of the GDPR. And in addition to these requirements, it must be also explicit. The sensitive nature of the data involved entails a consent that goes beyond the regular statement or clear affirmative action on the part of the data subject that you find in Article 4, paragraph 11. It means that the person must give an express statement of consent according to the wording of the guidelines on consent. You may also have noticed that Article 6 mentions one or more specific purposes. You have it here on the slide for Article 6, while Article 9 says one or more specified purposes. Again, the terminology is different from Article 6 and Article 9. Oops, too fast. The purpose in the second case must be clearly specified, which implies that the consent based on Article 9 must be tied to specific data or precise categories of data that the controller will be allowed to process. You understand that it's not so easy to rely on consent to develop health applications, but I should add that the consent lawful basis also raises important questions. Would consent be freely expressed if a government compels its citizen to install the application? If the use of the application is not mandatory, who would freely consent to be monitored around the clock, 7 days a week, including in the private sphere? And who is ready to freely consent to use a smartphone application as a passport to public transport, shops, and the workplace, as you might have seen that is the case in China or in other Asian countries? Wouldn't be the principle of using the app on a voluntary basis be perverted in this case? Because if you don't have the app, you don't use it, you won't have access to these services, these shops or these public transport, or even to your workplace. So you see that the concept of consent is important here, and we have to understand the repercussions of that concept while developing these applications. People would certainly be penalized if they refuse to install the app and in consequence are not able to access their workplace or their public transport, as I just said. If a person is blackmailed into using the app, she won't provide a valid consent under the GDPR. Another possible legal basis for collecting ID and location data could be the necessity to protect the vital interests of a specific person or group of persons according to Article 6, paragraph 1, letter D of the GDPR. Vital interest here means an interest which is essential for the life of an individual under recital 46 of the GDPR. It includes trust. It includes the threats to the physical integrity of a person or any other person, and the monitoring of epidemics and their spread, according to this recital 46 GDPR. We see that the GDPR was indeed ready for difficult situations, as Alexei mentioned in the introduction, including this health crisis. The vital interest legal basis also yields important questions, especially when it comes to geolocation. These data can be used to infer several details about an individual's lifestyle and personal choices. You must have heard about that man infected with coronavirus in South Korea. He was tracked down to a gay club, and all the contact, the authorities using the tracing contact, the traditional method of tracing contacts, turned into forcibly outing some gay people who visited this gay club and who had that contact with that man who was tracked down. I'm not sure if it was directly an application in this case. I didn't find all the information in the news. Here, location in this example, location data reveal the person's alleged sexual orientation and information also considered to be sensitive by the GDPR. So we see that maybe this situation would have been treated differently if it would have happened here in Europe. More generally, we can ask ourselves other questions. Would the continuous monitoring of citizens' location necessary to fight the coronavirus and proportionate to the goal pursued by national authorities? Could health authorities or any developers establish a substantial connection between the systematic processing of location data and the stated purpose of preventing the spread of an epidemic? Is there a logical link between the processed data and the alleged legitimate objective? And finally, would it respect the data minimization principle that provides that only adequate, relevant, and necessary data must be processed? That's some of the questions that I thought about while preparing this presentation. If you try to base your application on this legal basis to process personal data. But this legal basis cannot be put forward to process health data, but an exception that is similar to it exists. Health data could be processed under the vital interest exception of Article 9, paragraph 2, letter C of the GDPR. However, the exception can only be invoked if the individual is physically or legally unable to give consent. It can be the case if the person is unconscious, for example, or is incapable of consenting because of his legal status, like a minor or an adult under guardianship. A second limitation comes to mind from the fact that the vital interest exception cannot be used as an alternative option if a person is able to consent and has refused to. Explicit consent must be sought after whenever it is possible. So the vital interest exception is essentially useful for medical emergency situation and can hardly be a legal basis to process data through an application. Sensitive data about a person's health may also be processed under the public health exception of Article 9, paragraph 2, letter I of the GDPR, if the processing is in the public interest. Maybe this exception is more interesting than the previous one for our case. Public health is generally defined in European legislation as all elements related to health. The expression is exemplified in Article 9 GDPR itself. It comprises explicitly the protection against serious cross-border threats to health, which includes communicable diseases, among other categories of threats. The statutory exception encompasses, therefore, data necessary to study or fight epidemics like the current one, which spreads over many European borders. Public health, on the other hand, refers to the public good and what is in the best interest of a group of individuals or society as a whole. A personal, corporate, or financial interest is not enough to justify the application of this exception. It definitely limits the scope of that exception to process health data through apps developed by the private sector. But it can be a good basis to develop these apps by public sectors or public sector working with non-profit organization, which is the case in many European countries. One last condition is attached to the public health exception. It has to be already part of the national legislation. Otherwise, it would require the passage of a new law. I base my observations on health applications because they attracted most of the attention and critics. But it could have been said the same about other methods to track the virus. The traditional method to trace human contacts used for previous epidemics in Africa, among other examples, requires the same attention about their compatibility with data protection laws. In France, for example, a derogatory law has been adopted 10 days ago to process health data. French authorities resort to two national records to store COVID-19 test results and contacts a contaminated person had. The identity of the contaminated person can be revealed to her contacts only if she gives her explicit consent. One question immediately comes to mind while reading these French derogatory provisions. Besides the identity of the person who was in contact with a contaminated individual, should information about their relationship be also collected? The CNIL, the National French Authority, said no, and the French government amended its bill to reflect the Data Protection Agency's concern. Now we can turn to the third and last part of our presentation, which is about processing health data by employers. Employers face an unprecedented situation as they need to protect their employees' health against an invisible enemy. Asymptomatic carriers of the coronavirus make it complicated for managers to take appropriate measures to ensure a safe working environment. And maybe it's the case of some of you who are listening to my presentation today. Possibilities of processing special categories of personal data in the field of employment is quite limited. There is an exception in Article 9, Paragraph 2, letter B of the GDPR, but the conditions to invoke it are quite strict. Employers can process health data only if it's necessary, if it is authorized by a member state's law or a collective agreement, and there are appropriate safeguards in place to protect the fundamental rights and interests of workers. First, there are no general rules applicable to the entire European Union, as some of the professionals here already know. So the exception to processing sensitive data can only be understood on a state-by-state basis. Member states may allow employers, through their legislation, to collect sensitive data for different reasons, including to guarantee the health and safety of employees at work. Generally speaking, employers cannot take measures that would infringe on the privacy of their employees. They have to respect the basic principles set out in the GDPR. The processing of health data needs to be proportionate to the aim of protecting the employee's health. And it's hard to conceive under these circumstances that an employer could collect health data that would go beyond managing suspected cases of exposure to the coronavirus. Employers cannot collect data systematically through medical questionnaires in search of coronavirus symptoms, surveys about an employee's recent travel or movement inside the country, or daily measures of employees' body temperature. It will not be considered proportionate to the aim of providing a safe working place unless a national law allows them to do so. It is the same problem with requesting employees to show a green code, like the example of I gave you earlier in the presentation of Estonia, this immunity passport that will allow you to go to work or to some other places. So it's the same kind of problem if an employer requests from his employees to show that application green code on a smartphone to authorize them to penetrate in the employer's premises. It will then be possible, if the exception is applicable, for the employers to process information about the identity of the concerned employee and the measures the employer took, like medical leave, distance working, or reference to an occupational physician. It's important to note that these collected personal data could be processed only for the specific purpose of coping with the pandemic and must be deleted as soon as they will not be relevant anymore. And this is the case only if there is a national law allowing the employers to use this exception. Employers could also rely on the explicit consent of their employees under the same exception I mentioned earlier in the second part of my presentation. They could ask their employees to willingly share information about their health condition if they suspect that they have been exposed to the virus or they show symptoms of contamination. Unfortunately, I wouldn't bet that much on that exception to process health data. Indeed, the European Data Protection Board, in its guidelines on consent, considers that the relationship between employers and employees are asymmetrical, so an employee wouldn't be able to express a freely given consent in this case. In any case, employers cannot disclose the identity of infected employees, as they have to respect the confidentiality of the collected data under Article 5, Paragraph 1, letter F of the GDPR, if my memory serves me well. They may inform their workers about the general situation, but without revealing the names of the persons or the person concerned, unless, again, it is necessary and a national law allows it. Otherwise, it could lead to the discrimination or stigmatization of these employees by their co-workers. The general rules are provided for by the GDPR, but to fully understand the extent of the rights of employers in the context of the pandemic, we have to turn to national laws, as I already said a couple of times. In France, to give you an example, employers are responsible for the health and safety of their employees in accordance with the labor code. Usually, an employee has to communicate to his employer only his sick leave certificate. He doesn't have to give any further details regarding his health condition or the nature of his illness. Positive testing to coronavirus still cannot be communicated to employers, as doctors are instructed to issue only a sick leave certificate in the general understanding of the law as it is. But the CNIL, the French National Supervisory Authority, mentioned that the rule can be different if the employee works with the public or in close contact with his colleagues. Because of the exceptional situation, the employee has to inform his employer if he has been contaminated or he suspects that he has been exposed to the coronavirus. If he works from home or doesn't have any close contact with anyone, he's under no obligation to disclose this information. I must admit that I read these recommendations from the CNIL, but I still didn't find the exact French national law that could give any legal basis forcing an employee to depart from the general rule that I just exposed, that he doesn't have to tell his employer that he has the coronavirus or he thinks that he might have the infection. But it would be logical to prevent in this crisis his co-workers from getting sick and not being monitored appropriately. Generally, employers have to rely on the occupational health services and cannot establish themselves flies with the body temperature or of their employees or their pathologies. However, the CNIL points out that the GDPR applies to the processing of data and doesn't prohibit checking the body temperature of workers and visitors at the entrance of the workplace, as long as no data is collected during the operation and the information isn't communicated to the management. It implies that no automated process can be put in place to measure body temperature through thermal imaging cameras, for example. More generally, screening campaigns organized by employers for their employees are not allowed in France, including surveys about their health condition, the health of their family, or their recent movement inside the country or inside a region, following the guidelines that I mentioned previously as the general rules. As you see, the processing of sensitive data, and especially health information during a pandemic, is essential, but it also relies on complicated mechanisms. I hope that I was able to clarify a little the current legal situation, and I remain fully available to answer your questions. Thank you very much for your attention.
Thank you, Louis-Philippe. That was very helpful and I would say very clear presentation. And now I'm a bit more confident that GDPR has quite strict rules for the framework combating COVID for the countries. So before your presentation, I was less sure that it is not in the gray area. So thank you. I hope it was also. I'm mostly interested in public public law, but we have also the question from the participant of this conference, which is mostly about private law and what shall do this private company. So could you give several examples on how to practically implement explicit consent in a company if it is not possible to have written consent or digital signature?
You mean to process health data by the employers?
I think yes.
Yeah, okay. As I said, it's not the best legal basis to process health data by employers because of this asymmetrical relationship between employees and employers. Because of course, the employers, if they ask for consent, there is an alternative. You say, yes, I do consent, or you pack your stuff and you go away. So you see, that's what is pointed out by the guidelines on consent, by the European board. It's exactly this relationship that is not equal, and it's really hard to rely on consent on this part. But it's a very complicated and difficult situation where if you don't give your consent to share this information, you may endanger the life of your colleagues. And for me, maybe that part can be, it again, really depends on the national legislation. But to stay with the example of France, the employers have the responsibility to assure that the workplace is safe, but co-workers, employees also have this, this responsibility to keep the working space safe, secure, for their colleagues and co-workers. So I would say that maybe in this particular situation, consent can be relevant because it's important to play your part in preventing the spread of the virus. So that's still for me a gray area. It will depend, I guess, on the interpretation of the different national legislation. But I would say that there is at least an opening on this side. I don't know if I answered your question and if I was clear. Can you just?
I think it was very important note, and I would presume that the question also was about the methodics, or like how you can collect consent if it's not written consent or digital signature. Are there any other examples of having this, getting this explicit consent?
Yeah, I understand the second part of your question. You remember that I've mentioned that Article 9 is talking about explicit consent. I tried to define shortly what it means, explicit consent, but it's true that I didn't give any examples. It depends where, what is the factual situation. If the employee is working from home, it will be, you will have to put in place a different way to make sure that the consent of your employee is explicit. But there is different mechanism that can confirm that the consent is fully expressed and is explicit. You can have like 2 layers of consent. You can ask and make, I don't know, like if your employee is working from home right now and you prepare the coming back at the office, you may get that first digital consent and then confirm it later when you will meet the employee in real life with his signature. There is this, that's the example, some examples given by the guidelines on consent goes towards, towards that way of dealing with this explicit consent, to have like a double check. Do you have first consent, like a digital consent, and then is it backed by an email, by another kind of form that is in a different part of a website, let's say, or you have the real signature on the paper. So it's different ideas of how you can make sure that the employee really understands on what is consenting, and he gives a very clear and explicit consent. And I hope that I was clear also.
Yeah, thank you. Because so now we have this clarification for what was this question about. So it was not about it was not focused on employees. It was mostly focused on this online services, for example, for tracking health and identification of COVID symptoms. Yeah. So, but I think that you answered this question. So if you have,
maybe I can. Yeah, maybe I can just add that. That's one of the main preoccupations that I have while researching this presentation, because I looked at different examples of applications that are in development right now or exist, and that layer of really make sure that the consent is explicit, that the person knows exactly what kind of data will be processed by the application, how it will be processed, and all these details that are very important for a person to make this explicit consent about processing health data under Article 9 of the GDPR. This layer seems to be absent from some of the applications, or at least the explanations that I was able to get how these applications work. So maybe it's something that needs still to be worked by different governments and organizations.
Okay, thank you. And so the next question is from me. It is more general. So as a human rights defender, I'm very interested in the European framework for privacy and how it was prepared. Was it well prepared or not for the crisis? And how do you assess, if you can make this assessment, of course? So was GDPR framework effective in this period, or it should be somehow amended, or it should be amended not like the text of GDPR, but the general framework and clarifications or member states' laws or something? So what do you think about this?
Yeah, I don't think that everything was perfect, but I think that basically there was some provisions in the GDPR, as I tried to demonstrate, that were already thought, having in mind these kind of situations. But I don't think that anybody could have imagined that it would go so far with all the confinement and all the information that needed to be processed quite fast in the hospitals, and how it was crowded in different hospitals. So it's maybe a little bit early to make to find lessons from the crisis. Did it work? How did it work? My main observation right now would be that maybe the GDPR in some countries at least was kind of forgot a little bit. It was put aside, or maybe it was also so recent, it entered into force like 2 years ago, and we're celebrating the second year exactly yesterday, I think. Maybe it's too early to fully implement all the provisions and to understand all the provisions completely of the GDPR. But I found, especially in France, some basic to process, some legally basis invoked to process health data that seem to be not really compatible with the provisions of the GDPR. So maybe there's some bad advices that were given to some organizations, even governmental organizations. And maybe we need more time to see if the problem was the interpretation or the application of the GDPR or the GDPR by itself. But yes, maybe when we're in a situation like this one, everybody, as I tried to demonstrate a little bit with one pool that I gave you, but some were even more, in some countries, people were even more willing to share their data without giving any second thought. Maybe in the crisis, maybe when you're scared, when you're afraid to die, you're ready to give everything. But maybe after a couple of months, we will think back on this situation and we'll analyze it a little bit differently. And we will understand that maybe the GDPR was ready, but we were not that ready to apply it fully, I would say.
Well, I got your point. Thank you. So I think we'll get back to this topic maybe the next GDPR day next year. So we'll be more informed about the results of these policies, different policies, and so we'll have more information.
Yeah,
so
and how it was implemented in different member states, and we will be able to compare the different experiences and see who did well and who did not so great. But I think it's a bit early to do that.
Seems a big piece of work.
Yeah, it seems to be. Yeah.
Okay, so we have another question. So it is also quite general, but so there is some clarification. So how non-EU citizens can protect their personal data in pandemic time abroad in European Union? I mean, hotels representatives will check the temperature and what else? Notify medical authorities about virus. How does GDPR cover this case?
I think it's the same answer that I already gave. It falls under there is a general rule about health data. You cannot process them unless there is an exception. So the rule is set in paragraph 1 of Article 9, and you have to find an exception under paragraph 2 to be able to process that kind of information. And we saw the example of employers, because there is a specific exception that can be applied to employers if there is a national law that provide this kind of exception. For hotels, that's a very good question. How would you process these data legally under the GDPR? I don't see any public interest in processing them under the public health and public interest exception. Is there any other exceptions? It doesn't come to mind, except, of course, the consent. And you can say, I refuse to give the services, letting you rent a room in my hotel if you don't provide an immunity passport, or if you don't accept that your temperature will be taken every day, and eventually there will be a little graph to see the evolution of your body temperature to make sure that you're not getting sick or your health condition is stable. And again, it will be kind of asymmetrical, because even in the general understanding of consent under the GDPR, if you don't consent and you don't have if the consequence of not consenting is not providing the service, it would be quite difficult to understand that consent is valid. But I must understand, I must say that I didn't think about this example of how hotels, for example, would welcome guests.
Well, thank you. So I think that it will have lots of examples when our borders will be open again. So
Yeah.
we'll have more and more examples of how this problem is tackled. Well, and we have some more minutes, Maria, or you want to shut us down?
No, you do have a few more minutes, indeed.
Okay, or you have questions.
Usually switching on the camera takes me a few more clicks, so I thought I'd do it in advance this time. But
Okay.
you do have 5 more minutes, so go ahead.
Great. So you're welcome to ask questions also. But first, I'm not an expert in public health, and also not an expert in international cooperation in public health. But let's imagine that we have several groups of countries. Like the first group is like European Union with GDPR framework, and the countries like Belarus or Russia or Kazakhstan, the countries which are not so respectful in terms of privacy, and they have no such strict rules as we see like in practice. So how do you think, is there any is there any possibility that this crisis and different approaches to managing data in this crisis will somehow affect international data transfer between different groups of countries? The countries which are more, I would say, more focused on GDPR framework, or the countries which are less, I would say, respectful to privacy?
Yeah, it's hard to answer without any clear example in mind, but I'm also not a specialist of the transfer of data in different countries, but the general rules that we already exposed will apply. And of course, it can be a way to stop or reduce the exchange of information, of data between countries from the European Union or other countries who has the framework that is recognized as the equivalent, and some other countries, like you mentioned, who don't have this kind of rules and this same preoccupation about privacy. Okay,
so at least this question should be somehow considered also by public authorities. Well, and we have,
of course, yeah.
Yes, and we have, I would say, the last question about immune passports. Do you think that an immune passport is a threat to privacy? What will happen if in some countries this will be obligatory? For example, Germany is planning to cancel them. So what do you think about this issue?
Yes, I think that immune passport have a very big impact on privacy. That's one of the main concerns that I have about the Estonian example. Their experience by using this immunity passport to be admitted in shops or the workplace, and where you will be able to, by a QR code, show if you're healthy or not. I really wonder what would be the perfect legal basis to process data by third parties that will be respectful of the GDPR. It's really something that seems to, for me, quite a problem, and we're not even talking about what would mean this immunity. We don't know much about how immunity works with the coronavirus so far on the medical side. So how can you translate into an application that would say, oh, you have a green code because you passed a test of immunity? Or in some cases, I know the example of Quebec, the province is developing also that kind of application, but they will use different data, the place of birth, the age of the person, his health condition, his pathologies, where he has been, and different other, they will cross this data with tests, different kind of tests. And they will provide a green, yellow, or red code. I don't know exactly how it will work. They're not yet experimenting it, but they will soon do it. And it raises a lot of questions, letting artificial intelligence and algorithms decide if you can enter a workshop or the public transport. It raises very important legal questions related to privacy, but also many medical questions and ethical questions also. It's an interesting topic. There was a very interesting paper in the Toronto Star this weekend about exactly this immunity passport and how we will show this immunity, especially when we're traveling. And we go back to your example. If Canada develops such an immunity through an app, will it be enough to cross the US border or to travel abroad, let's say in Europe? And how these different passports will be compatible between each other. There's still a lot of work to do, I guess.